morning, everybody. Welcome to our Power of Print P.o.P webinar series. This is our third week, and today we have with us the wonderful Charles Watson, General Manager, IR Policy and Governance with the Visual Media Association. I will introduce Charles and his speaking topic a bit further in a moment, but I certainly, as I always do in every opportunity, not only at the P.o.P, but throughout our other activities, is make an important call out to our valued sponsors. Ricoh Australia, our industry partners, have been a supporter of not only the P.o.P webinar, but the annual industry metrics, survey and reporting, various other initiatives, and of course with the recent announcements of support across the National Print Awards and introducing a new award, Women in Industry, funding an international tour for the deserved female to branch and explore their international network with a trip to the UK, as well as attending the very first and the largest globally Power Print webinar, the Power Print conference in London, UK in November with myself, which will be a wonderful trip, wonderful experience. And none of that could be on the table or available to our industry and our members without the support of Ricoh Australia. I thank everyone there at the team who are part of that and part of also bringing this information to our members. Our industry partner across the P.o.P webinar series, and also a long-standing supporter of not only the Visual Media Association but the industry more largely, is Media Super, our superannuation industry fund. Great supporters of the industry, and I really do shout out to the entire Media Super team for their support. And not only do that they support us across various initiatives, but they also attend members' businesses and talk with members and their employees about financial literacy, superannuation guidance, starting young, the benefits of that, but also working with our growing female employees across the industry. Women still remain disadvantaged across superannuation, and Media Super have a great program to assist women in really bolstering up their superannuation. I really encourage any member listening to reach out to Media Super. They come on site, they're really informative, they work well with our teams, and they do a great job in really ensuring all of our superannuation and we're all as secure as we would like it to be. So without further ado, I introduce our speaker today. Charles has worked across various of Australia's preeminent law firms and industry bodies for over 20 years. He's had a very long tenure even across our industry, starting with Printing Industries Association Australia, it's a short period with Print and Visual Communication Association, then the Real Media Collective, and now Visual Media Association. Those who have worked across with Charles across the industry and membership know he is a trusted advisor, a considered legal expert, and a devoted support person, sometimes during some of these complex matters of industrial relations and workplace relations. I am colloquially known as always saying everyone needs a Charles in their lives, and I stand by that still to this day. The number of times he supported myself through Visual Media Association matters, as well as members, I can't tell you the number of emails of support and thanks. Charles really does know his stuff, but he's also terrifically committed. Today we're going to talk about ill and injured employees, your obligations and rights. This is a very important topic. We must be across it. We must be prepared how to manage it, not only for your own, legal insurances, but also to get the best out of these situations so that you can support your employee and make sure that they're healthy and able to get back to work as soon as they can. I'm no expert. I'll hand over to the illustrious Charles Watson. Thank you.
Thanks, Kelly. Thanks for your kind words, and thanks to everyone for joining today. As Kelly mentioned, today we're going to discuss a complex, sometimes and somewhat unpleasant subject, but it's an important issue for members, and that is how to manage an ill or injured employee, and when and how an employer can lawfully terminate an ill or injured employee. Managing an employee's illness or injury presents members with potentially significant challenges. Members must sort of balance their business needs and their legal obligations with their duty of care toward their employees, all the while ensuring that you mitigate the risks associated with unfair dismissals, discrimination claims, adverse action claims. So I could probably speak on this subject for hours and still only scratch the surface. But in this presentation today, we're going to cover the legal framework governing these issues, some key employer obligations under the Fair Work and other pieces of legislation, the role of medical assessments in determining an employee's capacity for work, some risks and legal exposures if the processes aren't handled correctly, and some good practices for ensuring that you're compliant and that you reduce associated risks. So by the end of today's session, hopefully you'll have a bit of a clear understanding of what is lawful and reasonable and fair when managing your ill or injured employees, and when, unfortunately, if it comes to it, considering the termination of an ill or injured employee. So let's begin with the legal framework and related employer obligations. It's essential to remember that various pieces and numerous pieces of legislation can apply in these circumstances, both state and federal laws and legislation, and sometimes they apply simultaneously and with variances and individual subtleties. I'd like to highlight a few of those pieces of legislation and the related schemes that are likely to apply. So under the Fair Work Act, an employer must not dismiss an employee due to a temporary absence caused by an illness or injury. A temporary absence is defined as 3 consecutive months of absence or a total of 3 months over the previous 12-month period. However, if the employee's absence extends beyond that protected period, an employer may consider needing to, or may consider terminating an employee, but again, only if proper steps are taken and taken carefully. The rules change though when an injury or illness is work-related. Each state and territory has different laws regarding termination during a workers' compensation claim. So for example, in New South Wales, an employer cannot legally terminate an injured worker for at least 6 months after they become unfit for work due to a work-related injury. The old New South Wales Industrial Relations Commission still has jurisdiction to reinstate an employee who's on workers' compensation if they have been terminated within that 6 months period. Other states and territories have similar but varying periods that may apply. So members need to carefully check and follow their obligations under state-based workers' compensation laws when making any related decision. Additionally, and this is sometimes forgotten, employees themselves need to comply with their participation requirements and obligations under workers' compensation laws. Under the Disability Discrimination Act, which is a Commonwealth Act or Federal Act, employers must not discriminate against an employee based on a disability and that includes an illness or an injury. So before an employer considers acting, you need to ask yourself, can the employee perform their role with adjusted duties? Could modified hours or alternative working arrangements or related arrangements help? Is there another role within the organisation the employee could reasonably perform or undertake whilst they are injured? So given there's sort of this general legal requirement to make reasonable adjustments, if those options aren't explored, an employee could potentially face a disability discrimination claim. And given pardon my cynicism, but given the nature of the various jurisdictions and commissions that could review such complaints, I'd highly recommend you do not end up before them. So whether an employee whether an employee can be accommodated with reasonable adjustments is a key consideration. However, one size does not fit all, and your considerations need to be specific to that individual employee's circumstances and condition. The Disability Discrimination Act does set out potential exceptions where the employee can't perform the inherent requirements even after reasonable adjustments have been considered or have been made, or where those otherwise reasonable adjustments would cause you as an employer an unjustifiable hardship to implement them. This could include if making that adjustment is too expensive, if your company isn't resourced to make those adjustments, or if the adjustments are just too time consuming or too difficult. So let's look at how employers may assess whether and when termination could be justified. So unfortunately, there may be circumstances where an employee is no longer able to perform their role as a result of an injury or the effects of an illness. There are a number of steps you need to take along the way and to consider before making any decision to end their employment. You need to look at assessing their capacity for work is the first point. As an employee, you must determine if the employee can or cannot perform the inherent requirements of their role now and into the foreseeable future. So to do that, you need to obtain medical evidence from their treating doctor, from your employee's treating doctor, and perhaps preferably, where possible, have the employee undertake an independent medical examination or an IME if reasonable grounds exist. It's crucial that employers provide any medical practitioner with a detail, whether it be the employee's medical practitioner or an independent medical examiner practitioner, that you provide them with a detailed position description that outlines the essential duties of that employee's role. The medical practitioner's opinion should specifically address whether the employee is fit to perform those duties and whether any reasonable adjustments could assist. So an employer can request their employee undertake an IME, but as long as you have a valid reason, and you can request the employee undertake an IME if there's conflicting medical information, perhaps between the employee's treating GP and a medical specialist that they may be seeing as well. It could be reasonable to require an IME if the employee has refused to provide information from their treating practitioner or if there's a reasonable need for an independent and unbiased opinion. Now, you can't force an employee to undergo an IME unless there's clear justification, such as conflicting medical reports, and as long as the direction is reasonable and lawful. So, where possible, I'd recommend you attempt to get consent and agreement from your employee before giving them the direction to attend an independent medical examination. So if that's the case that the employee, or if it is the case that the employee refuses to attend an IME and you have reasonable and valid reason to direct them to attend, you nevertheless need to tread carefully. While there are many decisions where an employee who unreasonably refused to attend an IME could be seen to be an act of misconduct. Conversely, immediate termination could result in some form of an unfair or dismissal claim or similar claim. So when it comes down to you've obtained all available medical information, including reports from treating doctors, any IME, you need to, as an employer, then carefully assess whether the employee is able to perform those inherent requirements of their role, whether any reasonable adjustments could enable the employee to safely return to work, and also whether the employee is likely to regain capacity, full capacity, in the foreseeable future. So if after considering those that evidence and those issues, it's clear that they can't perform the inherent requirements and there is no reasonable prospect of improvement, then, and I would recommend only then, could an employer lawfully consider proceeding to termination, provided that all procedural steps, proper consultation, providing the employee with an opportunity to respond, as long as those are followed. But it's critical that termination decisions are based solely on objective medical evidence, not assumptions or perceptions about an employee's condition. But it's certainly not going to be a quick process. So let's look at some of the risks and potential legal exposures that may be faced by employers. So there's the obvious unfair dismissal claim. If an employee, or rather if an employer terminates an employee too early without valid reason and without having undertaken due process, the employee can file an unfair dismissal claim with the Fair Work Commission. And if an employer hasn't got that valid reason and they haven't followed due process, that claim may well succeed. So to avoid this, you must be able to evidence that you made the decision based on solid medical evidence. You gave the employee that opportunity to respond, and that there were no reasonable alternatives other than ultimately termination. The next possible exposure you may face is an adverse action claim. Employee may file what's called a general protection claim in the Fair Work Commission if they believe their employee took adverse action against them by dismissing them because of their injury, their illness, or a related disability. Unlike unfair dismissal claims, there's no cap on compensation in an adverse action case. So that can make them potentially or much more of a significant financial risk to employers. In relation to workers' compensation and return to work obligations, if an employer fails to follow any return to work obligations, you can potentially face fines or penalties from your state work safety regulators. And then in dealing with medical information, you should always obtain a written consent before seeking medical information from an employee's doctor. In that, if you mishandle what is considered private medical data, you could potentially face breaches under Australian privacy laws and possibly legal exposure or legal action for unauthorised disclosures. So clearly, termination is a high risk process if it's not handled comprehensively. So some good practices and some key takeaways perhaps for today. Failure to follow due process will likely result in a legal claim, potential financial penalties, and related risks and reputational consequences. So some good practice for members is to ensure compliance through maintaining clear records of medical reports and related discussions you've had with your employees, follow a fair and consultative process before making any related decision, particularly when it comes to termination of someone's employment. You need to explore the potential for making reasonable adjustments in your business before making that final decision. Be aware of the state-specific and federal laws, workers' compensation laws, etc., that can apply. And as always, seek advice to avoid or at least mitigate any potential exposure. So in summary, employees can lawfully terminate an ill or injured employee, but only if the employee cannot perform the inherent requirements of their role at a certain point in time, and even with potential reasonable adjustments. And I'd finish by saying that employers must follow correct process to avoid unfair dismissal claims, discrimination claims, or adverse action claims.
Thank you, Charles. Appreciate that. It's, again, always very thorough. A couple of quick questions. We've got a little bit of time. I'm just mindful of time, but we've got a couple of quick questions. Reasonable adjustment. This is something I'm struggling with a little bit. I always have. Just for everyone out there, can you give us some information on what that actually means? The old layman's term that helps me well, but just that reasonable adjustment definition. How would you go about explaining that?
Yes. In some respects, you're right, Kelly. It's how long's a piece of string and what does it involve? But reasonable adjustments are any form of assistance or adjustment that's necessary and reasonable to reduce or eliminate barriers to an employee performing their work. Those adjustments are personalised to the individual employee's circumstances and their requirements. Deciding whether a reasonable adjustment can be made sort of requires an analysis by an employer of the requirements of the employment as a whole. So employers shouldn't take too narrow a view on what is a reasonable adjustment. Considerations may include potential sort of physical adjustments to a workplace, offering a different position or role if it's available to, or an alternate version of the current role to that employee, adjusting perhaps an employee's hours or days of work Are there some tools or equipment that may be utilised, or some other form of modifying technological assistance? It could also include determining whether assistance from co-workers was necessary. So if the adjustments that you could consider making, if they're modest, then you'd need to sort of show good reason as to why they weren't implemented. Those adjustments might be temporary, they may be permanent, but any agreement with an employee over what are reasonable adjustments should also include a periodic review for their ongoing suitability, and where it's not possible to make a reasonable adjustment, or if there's no alternative role and the medical evidence states that the employee can't perform their inherent requirements now or into the foreseeable future, then that last resort, if you will, may be the ending of the employment relationship.
Yeah, I think that's sort of that modest, well communicated, reviewed. When we sort of hear this reasonable word, I think if anyone's out there listening, it's those steps, dramatic, all those sorts of things. They're not reasonable. So considered, modest, communicated, and then reviewed. They're all things that assist in that reasonable definition, aren't they? And I think that's really good advice. Thank you. The other question is about sometimes, we've had members contact us about their doctors sign them off, and we're still not sure, whether they are actually ready, and also for that, given the nature of the injury, and that they've sustained and their duties, where does an employer sit in that position?
Okay. In those circumstances, I'd recommend that an employer speak with their employee to advise them that while their doctor has provided them with a medical certificate and clearance to come back to work, you as an employer require somewhat more of a functional assessment of them against the requirements and duties of their role. I often see situations where an employer has been presented with a medical certificate saying, well, Fred's good to come back to work. He can only lift 10 kilos though. But then what if their role requires them to lift 15 or 20 kilos, but perhaps only twice during the day? Also, I'll see instances where employers are presented with a medical certificate saying the employee is undergoing treatment, but it doesn't deal with the employee's capacity to perform their role with clarity. So it's good practice that during your employee's absence for illness or injury, consider potentially to liaise with them, contact them, and advise, especially with an injury, and advise them that their treating doctor needs to report on their capacity compared to the role and the inherent requirements of that role, so that any medical clearance properly addresses capacity before someone returns to work. If it's possible, provide your employee with the full range of their duties, and ask them to get their doctor to assess them against those, or consider, as I sort of said or referred to earlier, is getting permission from your employee to liaise directly with the doctor or with their doctor on the issue. And I've seen where if an employee's treating doctor isn't au fait with things such as musculoskeletal issues or similar, it it then may be necessary to send your employee to receive that IME to correctly determine their capacity to return to work. As I've said earlier, that you don't want to act prematurely, and any decision you make about your employee needs to be based on as much detailed information as possible, and whether any reasonable adjustments can be made for what period of time, etc., so as to accommodate their condition.
Thank you, Charles. I appreciate all of that. I know that we're a bit out of time. I could have sat here a bit like you and chatted away for a bit longer on this.
For hours.
I know
Yeah.
there's hours. It's look, I think what I'm hearing really loud and clear is communication is critical across all of these processes, and document that communication, not just verbal and walk away. Document that communication. Reasonable is about modest steps. There's also communicating those and continuing to review them. Take caution if you have concerns, and we just talked about that in some of those questions. But really, communication is key. And often, Charles, with all the work that you do, across all matters, that often seems to be most important before things escalate. If we've got a good communication process and things are well documented and shared, it's always a lot easier to navigate some of these very complex matters. Thank you for the summary. Thank you for your presentation and a few curlies in the Q&A. Again, a big, huge thank you to RICO Australia, our sponsors. Couldn't do it without you, and also industry partners, Media Super. Next week, we have skills and training. One of the hottest topics across the industry from our members is around skills and training, and how we can continue to focus on skills and training, grow skills and training, develop our qualification process, and also move into supporting not just apprentices, but trainees, cadets, and all the other wonderful people that make our industry what it is. I look forward to week 4 with everybody. Thank you again, Charles. Thank you to the entire Visual Media Association team for behind the scenes work on this, and especially a shout out to London Mills, who pulls all of this together for us and allows us to turn up and say hello, and we look very well polished. There's a reason for that. We're very well briefed, so thank you, London and the team. Have a great week, and we'll see you next week.